Well, good afternoon, everyone, and welcome to this Francis Taylor Building Public Law webinar. The topic today is parliamentary privilege. For those who don't know me, my name is Richard Honey. I'm a barrister at Francis Taylor Building. Until recently, I was chair of the Public Law Practice Group here at FTB. Kate Olley has now taken over that role, but I'm chairing this seminar today. It's great to see so many people have booked and logged in for the webinar today. I guess everyone's familiar with the way Zoom webinars work nowadays. We'll take questions via the Q&A function on the system. You should be able to access that by clicking on the icon at the bottom of your screen. Please do feel free to type questions as we go. We'll answer questions in a block at the end after the talks, or as many as we've got time for, at least, because we're going to stop at 2 o'clock, even if we've not got through all of the questions. All being well, our speakers will be able to share their screens to show PowerPoint slides during their presentations, but we're going to email copies of the slides out afterwards as well. And we're going to be recording the webinar and publishing it hopefully afterwards on the FTB YouTube channel. So, as I say, the webinar today is intended to give an overview and an update on parliamentary privilege. As you'll hear, parliamentary privilege supports the separation of powers under the Constitution and allows Parliament to perform its legislative and scrutiny functions without external interference, including by the courts. What that means in practice, though, is that parliamentary privilege limits the extent to which parties in public law litigation can use parliamentary materials, things like Hansard and ministerial statements and various reports, to support their cases in the courts. And of course, this is an issue that affects both claimants and defendants. It's been an issue in quite a number of recent cases in a whole range of public law fields, including human rights, immigration, leasehold reform, planning and environmental cases, including some really quite high profile cases like the challenge to VAT on private school fees. So it's excellent that we've got two good speakers today to help us understand parliamentary privilege. And our speakers are Dr. Elizabeth O'Loughlin and Gabriel Nelson. Gabriel's going to speak first, and he's going to chart the historical context and development of parliamentary privilege. And then Elizabeth is going to discuss some recent cases, including parliamentary privilege as it applies in Wales to the Senedd, and a number of other recent cases that show the tensions and limits of parliamentary privilege. I'm going to introduce our two speakers properly as they come to speak. Please do type any questions you've got for them in the Q&A function as we go. So I'm going to start now by introducing our first speaker. That is Gabriel Nelson. Gabriel was called to the bar in 2023 and is already developing a broad practice in public law, planning and environmental law. He's acted, for example, for claimants in planning and environmental judicial reviews, advises on a wide range of local government matters, and covers a broad number of public law fields, including, for example, immigration, police and parole, and has also been doing some quite a lot of work for the Office for Environmental Protection as well. So Gabriel, if you would like to share your slides so that we can see them, please, then I will hand over to you.
Thank you, Richard. Great. Thank you for that handover, Richard. So as Richard said, I'll be addressing the historical context and development of parliamentary privilege. And just by way of a brief introduction, the concept of parliamentary privilege, as many of you will know, has evolved over several centuries. And its modern foundation, if you can call it that, was established in Article 9 of the Bill of Rights, 1689. And I would say that the historical development can be split into two broad categories, and that would be the early stages. So I've split it into the Tudor and Stuart periods, where the main theme was Parliament's stand against executive interference, and that was in the shape of the monarch. The later stages, the second periods, were largely the Georgian and Victorian periods. The main theme there was Parliament's struggle with the courts as to the jurisdiction and scope of the privilege. So the existence of privilege had been established, but then the question became, well, who is the arbiter of that privilege and what is its scope? Now, in the present day, the principle is relatively settled, though, as Richard alluded to, there's still considerable debate in case law regarding the principle's extent and how it should be used. And I'll address that briefly at the end of my talk. So, firstly, addressing the early stage of the historical context. So, free speech was already being exercised by members of parliament by the late 15th century, though it was considered more a matter of tradition than a privileged right, and an excellent resource for all matters of parliamentary privilege is obviously Erskine May. And one instance is Sir Thomas More of Utopia fame, if some of you have read that book, who was at the time the Speaker of the House of Commons, and he appears to have been the first speaker to try to claim the freedom of speech as a privilege of the House. And then by 1563, so we're in the period of Elizabeth I, Parliament was claiming freedom of speech as an ancient right. And unfortunately, we don't have Elizabeth's reaction to this claim for parliamentary privilege, but we do have Sir Edward Coke's response in 1593, where he gave the sovereign's view, and he put it this way, which is that Her Majesty granteth you liberal but not licentious speech, liberty therefore, but with limitation, to say yea or nay to bills. God forbid that any man should be restrained or afraid to answer according to his best liking, which is the very true liberty of the House, not, as some suppose, to speak there of all causes as him listeth. No king fit for his state will suffer such absurdities. So now we can move into the Stuart period, and this is where things get really interesting, I would say. And this is the expansion of parliamentary privilege as a right or a tradition, and how that buttresses against the ancient perceptions of the absolute right of the monarch. And an excellent example of that is James I's famous phrase that Parliament is there by the grace and permission of the monarch. So the monarch pre-exists Parliament and may take that privilege away. And as some of you all know, Charles I is an infamous example of how the monarch and Parliament interacted. Many instances, but one which is perhaps most famous is when in 1629 he arrested two members of Parliament for committing seditious libel for words spoken in debate in the House of Commons, and that led to a famous case called Elliot's. And then in 1642, so right prior to the Civil War, Charles entered the House of Commons with an armed escort to arrest five members of Parliament. And when the King demanded that the Speaker of Commons identify those five members, the Speaker responded, I have neither eyes to see nor tongue to speak, but as this House is pleased to direct me. And obviously, as we all know, this culminated in the English Civil War. And one interpretation of that war would be a battle between parliamentary privilege and its encroachment by the monarch. So where did this end up, all of this conflict? Well, we can pretty much pinpoint it in the Bill of Rights. And this gave statutory expression to freedom of expression or freedom of speech in Parliament. And the preamble is informative of why the bill was introduced. And it states, because King James II, by the assistance of diverse evil counsellors, judges, and ministers employed by him, did endeavour to subvert and extirpate the laws and liberties of the kingdom. And as I stated earlier, freedom of speech is famously asserted in Article 9 of the bill, which provides the freedom of speech and debate or proceedings in Parliament ought not to be impeached or questioned in any court or place out of Parliament. And those are two lines which have given rise to reams and reams of judicial interpretation. And it's important to note that Article 9 is capable of variation by primary legislation, but it's not capable of waiver, even by a parliamentary resolution. So now we have the right in place in its statutory expression. So how was that right interpreted by both Parliament and the courts? And what is the scope of that right and who may determine it? And that was the question, in essence, determined by the courts in the 17th through to the 19th century, in essence. Um, and the courts considered a range of claims of privilege by members of the Parliament. And an example of that would be the killing of rabbits belonging to the member of House of Lords, or fishing in the pond of a member of the House of Commons. So we can see how far views on privilege diverged. And Lord Brougham in Wellesley warned courts of law how incumbent it was upon them to defend their sacred duty against wild and extravagant notions of privilege. And perhaps the most significant development in this period was the case of Stockdale and Hansard. And in that case, an action was brought in defamation against Hansard as a publisher of proceedings in Parliament. And the court held that parliamentary privilege protected papers printed by order of the House for the use of its own members, but that this protection did not extend to papers made available to members of the public. And Parliament overturned that decision in the Parliamentary Papers Acts, and that provided protection for parliamentary papers published to the public. And that act remains in force and reflects the law as today. And also, as we all know, there's the rule in Pepper and Hart, which allows courts to refer to ministerial statements and the like, where the interpretation of legislation is unclear. So that's the historical context and development. What is the modern conception of parliamentary privilege? And that's defined in Erskine May's parliamentary practice as the sum of certain rights enjoyed by each House collectively as a constituent part of the High Court of Parliament and by members of each House individually, without which they could not discharge their functions and which exceed those possessed by other bodies or individuals. And this incorporates many elements, one of which is obviously freedom of speech, as I've already discussed. The other would be exclusive cognizance, and that is the principle that Parliament has exclusive jurisdiction over its own affairs, and that was recognised in the well-known case of Bradlaugh and Gossett, which concerned Parliament's proceedings over the oaths given by members of its House, and also the judgment of Lord Reid in Picken and British Railway Boards, where the House of Lords declined to go behind the process for the making of a private act of Parliament. So, put simply, where matters fall within the scope of parliamentary privilege, it is for Parliament to determine its application. But obviously, there's inevitable tension there between courts being the arbiter of the scope of parliamentary privilege. So, where does the scope end and the application begin? And the rationale for parliamentary privilege, and I think the best explanation of that I could find was Lord Burnet, who was the former Lord Chief Justice. And the rationale is this: a parliament that fears action through the courts for what is said in parliament, whether by the executive, private bodies, or individuals, is one that cannot discharge this duty. It would not be able to carry out its representative function effectively. It would not be able to develop and enact legislation effectively, and it would not be able to scrutinise the government and hold it to account. So, put simply, Parliament couldn't do its job without its privilege. However, there is a potential for misuse, and this was recognised at the court in Adam and Ward in 1917, which stated that while the protection provided by the privilege exists for motives of high public policy, particularly where freedom of speech was concerned, it was not to be turned into an abominable instrument of oppression. And Chater, I think, is a good example of the potential misuse of privilege. And this case concerned the parliamentary expenses scandal, which many of you will be familiar. And the issue was whether matters concerning claims by parliamentarians for expenses could form the subject of criminal prosecutions, i.e., was it covered by privilege? And prosecutions were brought by the Crown Prosecution Service, and the defendants argued that such expense claims were subject to parliamentary privilege, thus out with the court's jurisdiction. And the court very thoroughly goes through the development of the relationship between the courts and Parliament concerning privilege, and found that it was for the courts to determine whether something fell within the scope of privilege. And Lord Phillips explained that the question rested on whether scrutinising the expenses claims in criminal proceedings would have an adverse impact on the core or essential business of Parliament, and whether it inhibit debate or freedom of speech, i.e., does it run contrary to Lord Burnet's quotation that I cited earlier. And he found that such scrutiny would not inhibit any of the varied activities in which members of Parliament indulge that bear in one way or another on their parliamentary duties. The only thing that would inhibit would be the making of dishonest claims. Another good example of the potential misuse of parliamentary privilege is that of Peter Hain and Damien Green, which some of you may be familiar with. And this case concerned an injunction brought by Mr. Green against the Telegraph to prevent a publication of a story that concerned allegations of serious sexual harassment and bullying. And the Court of Appeal granted an interim injunction and set directions for an expedited trial. The Telegraph, in the meantime, published an article about how powerful businessmen using non-disclosure agreements and who had been accused of sexual harassment and racist abuse, but did not name Mr. Green himself. However, Lord Green in the House of Lords named Green as being the subject of the article, and Mr. Green then had to discontinue his claim because the object of it had been essentially defeated by Lord Hain. And that issue went to the European Court of Human Rights in Green in UK. And Mr. Green alleged a breach of Article 6, so the right to a fair trial, 8, the right to freedom of privacy, and 13, which is the right to effective remedy. And the court found no breach. However, it did note that appropriate controls over the exercise of parliamentary privilege must be kept under regular review. And this is the quotation, given the serious impact that the disclosure of such information may have on the privacy of the individual concerned, not to mention the implications for the rule of law and the separation of powers within the United Kingdom Constitution of parliamentarians usurping the role of judges, who have considered it necessary, after viewing the evidence before them, to grant an injunction. So no breach, but certainly keep the matter under review. And this is where reform comes in. So there was a Joint Committee on Parliamentary Privilege appointed in 1997, and this recommended that a Parliamentary Privilege Act be passed, which would codify privilege and the rules around contempt, clarify the scope of freedom of speech, and include members of both houses within the scope of legislation on corruption, restrict the exclusive cognizance principle that I referred to earlier, and transfer penal powers over non-members to the courts, and finally replace the Parliamentary Papers Act in 1840, which overturned Stockdale and Hansard, which I referred to earlier. No progress was really made on those recommendations, and a second joint committee was appointed in 2012 and 2013, and this took a different approach to its predecessor, and this committee concluded that there was no need at present to codify the law around parliamentary privilege. However, it did make some specific recommendations about certain areas, such as the power of each house to investigate and punish contempts, and the law on reporting and broadcasting parliamentary proceedings. So in short, certainly a debate about reforming the law around parliamentary privilege, but certainly no clear idea about how that reform will happen or occur. Thank you very much.
Thank you, Gabriel. We should probably clarify, my understanding is that the Mr. Green who was named by Peter Hain in relation to those allegations was Philip Green, rather than Damien Green. I think Damien Green was involved with parliamentary privilege issues at some point because he was arrested and his house was raided in relation to providing papers, I think, to the newspapers, in a kind of whistleblowing approach. But it was Philip Green, I think, not Damien Green, who was the one that was named by Peter Hain for those things.
Thank you, Richard. I've messed up my greens there, so thank you for that.
No, well, there's more than one Green that's been involved in parliamentary privilege issues historically, showing just how common they are. Well, thank you, Gabriel, for that canter through a number of centuries worth of parliamentary privilege. Just a reminder, if you've got questions or comments, please do use the Q&A function to ask them. And that brings us to our second speaker, who's going to bring us right up to date. That's Dr. Elizabeth O'Loughlin. She is Associate Professor in Public Law and Human Rights at Durham Law School. She's a public lawyer who researches in the fields of comparative constitutional law and administrative law, including looking or using empirical approaches to understand how judicial review works in practice. Elizabeth has got a PhD from the University of Manchester and an LLM by research from the European University Institute at Durham, where I think Gabriel studied. Elizabeth teaches on the public law and human rights modules across undergraduate and postgraduate taught programs. She served as co-director of the Human Rights Centre there between 2019 and 2021, and in addition was co-convener of the public law section of the Society of Legal Scholars from 2021 to 2024. And we're delighted that Elizabeth has just accepted an invitation to join the academic panel here at Francis Taylor Building. So we're looking forward to her being involved in more Chambers discussions in the future. Elizabeth, over to you.
Thank you very much for that introduction, Richard. And just to say a huge thank you to Francis Taylor Buildings for inviting me to speak today, and to Deirdre for organising. And it was great to hear, yes, that real whistle-stop tour over centuries from Gabriel. I really, really enjoyed it. So the subject of my presentation today, my intention is to go through a series of recent cases on parliamentary privilege to pull out some what I think might be key themes and potential areas for future development going forwards, on the basis of some of the cases that we've seen in the last couple of years. The first theme, if you like, that I want to start with is a key principle that was asserted in a fairly recent case called the Project for the Registration of Children as British Citizens, which is on the topic of when parliamentary materials may be used in litigation. A very clear statement for the court in this case that it cannot be used to address evidential gaps, particularly by public authority defendants. Before diving into some of the detail of this case, I thought I might start to just do a bit of a whistle-stop tour over when, in general, it has been accepted that parliamentary materials may be made use of in litigation. And on this, we can make excellent use of the relevant paragraphs of the Heathrow Hub Court of Appeal case from 2020, which provided an absolutely essential summary identifying 6 circumstances of when parliamentary materials may be used in litigation. So in brief, the first being that courts may admit evidence of proceedings in Parliament to prove what was said or done in Parliament as a matter of historical fact where this is uncontentious. Parliamentary material may be considered in determining whether legislation is compatible with European Convention rights. The court, as Gabriel noted, may have regard to a clear ministerial statement as an aid to the construction of ambiguous legislation, particularly where it helps identify the mischief that the legislation addresses. The courts may have regard to parliamentary proceedings to ensure that a relevant statutory process has been complied with. The courts may have regard to parliamentary proceedings in the context of the scope and effect of parliamentary privilege. And finally, for our purposes, this one's particularly key. An exception has also been identified for the use of ministerial statements in judicial review proceedings. The Speaker in Heathrow Hub case accepts that such an exception exists, but contends that the scope and nature of this exception has not yet been the subject of detailed judicial analysis. It calls for careful consideration of the constitutional issues involved. So, with that in mind, I'd like to go back to the slightly more recent follow-up case of a project for the registration of children as British citizens. This case is a Court of Appeal case which concerned a successful challenge to the Secretary of State decision applying a fee for children applying for registration of British citizenship of over £1,000. And the challenge was successful on the basis that the Secretary of State had failed to consider the best interests of children in making these regulations, and they were required to consider the best interests of the children by Section 55 of the Borders, Citizenship and Immigration Act 2009. In the course of appealing that finding of unlawfulness, the relevant Secretary of State, the Home Secretary, filed a witness statement by an official designed to demonstrate that they thought they had performed their duty under Section 55 to consider the best interests of children in establishing this fee. The submission was that by examining the speeches made and questions asked by members of both houses and responses given by ministers, she was able to show that in the course of those debates, she had performed her statutory duty. The court was not willing to accept this in the Court of Appeal. The court went on to say, paragraph 108, this use of parliamentary materials went far beyond just informing the court of, for example, the reasons for a particular decision. And by way of provision of the quotation that I give there, the court also said, not only did the witness statement fail to actually demonstrate that they'd taken into consideration their duty under Section 55, the Secretary of State was relying on the debates in an attempt to fill the evidential gap left by that failure. And that went far beyond what was something that can be made use of by way of parliamentary materials in litigation. So that's one theme that I've picked out from recent case law. The second theme or development that I'd like to draw your attention to is how the use of parliamentary materials or statements interacts with the establishment or the founding of legitimate expectation, particularly in judicial review. And on this, I'm going to be drawing your attention to some recent conflicting authorities on this issue. The first is the 2024 Donald case. So this case concerned a challenge to the decision of the Secretary of State not to implement 3 of the 30 recommendations arising from the Windrush Lessons Learned review. And that was an independent, I'm sure many of you know, was an independent assessment of the events leading up to the Windrush scandal. That application was granted in part with a finding that a procedural legitimate expectation had been created by the relevant Secretary of State that they would consult relevant stakeholders before substantially changing how they would respond to the review. For our purposes, we're more interested in a failed argument that the Home Office's comprehensive improvement plan created a substantive legitimate expectation that all recommendations would be implemented. And as part of that argument, questions arose about the admissibility of a Home Secretary ministerial statement to the House of Commons, which was relied upon by the claimants as one of the representations giving rise to an alleged substantive legitimate expectation that all recommendations would be implemented here. In the course of that discussion, Mrs. Justice Williams takes the view that ministerial statements can be used to establish a legitimate expectation. That was in spite of some recent case law, including the Heathrow Hub Court of Appeal case, that has expressed quite clear doubt that ministerial statements can be used to found a legitimate expectation claim where there is a dispute as to whether a statement is clear or unambiguous. Miss Justice Williams' view in this case, this High Court case, is that there is a distinction between questioning what has been said in Parliament and relying upon what has been said in Parliament. She said here that she doesn't think that issue arises in the present case. It is a matter of record that the relevant statement was made to Parliament. There is no dispute as to what was said. Whether the statement taken with the other material relied upon gave rise to an enforceable legitimate expectation is a question of law. So that is quite interesting because it seems to be a statement from the High Court that uncontested statements and an assessment of them might give rise to the court being able to look at whether that creates an enforceable legitimate expectation. That is to be contrasted with the more recent decision in D1914. This case concerned a dismissed claim for judicial review of the Home Secretary's response to the Brooke House inquiry, that being an inquiry into the mistreatment of individuals detained at the Brooke House Immigration Removal Centre. The court also, in that case, granted an order prohibiting the claimants from relying on material which was subject to parliamentary privilege and where its intended use constituted, in the court's view, impermissible questioning of proceedings in Parliament. In the course of the case, the claimants sought to rely on a variety of different parliamentary materials, parliamentary committee reports, evidence given to parliamentary committees, a National Audit Office report, and a written ministerial statement to the House of Commons. The claimants submitted that they had a legitimate expectation from the Home Secretary's ministerial statement that steps would be taken to ensure that the mistreatment identified in the statutory inquiry would never reoccur, essentially. And the finding of the court here was a clear view that the court agreed with the Speaker who intervened here, that the Heathrow Hub case makes quite clear that there is no ability to use ministerial statements to found a legitimate expectation claim where there is a dispute as to whether a statement is clear or unambiguous. She says, in my view, the court says, in my view, adjudicating on the question of whether a minister has made a promise that was clear, unambiguous, and devoid of relevant qualification necessarily involves interpreting and drawing inferences as to the meaning of the statement, thereby questioning it, not just relying on it. She then says the fact that the other cases have assumed without argument that a statement in Parliament could found a legitimate expectation does not determine the outcome here. She goes on to distinguish a series of cases where ministerial statements have been accepted as one constituent element of a position on behalf of a government. She draws attention in particular to the case of Finucane, where statements that had been made in, I believe it was the Northern Ireland Assembly, were actually also supported by the same assurances outside of Parliament. So not necessarily clear-cut examples of the ministerial statement being the founding of the expectation. She followed the Speaker's directions to the high authority of the House of Lords case of ex parte Kebelline here, back from the year 2000. And I think one of the things that's interesting about the debate here about whether ministerial statements can be used to found a legitimate expectation is I think this issue perhaps might not quite be settled yet. It might be the case that there may be situations in which parties might agree amongst themselves that the statement in question in the ministerial statement is uncontentious, such that it might meet that first requirement of finding a legitimate expectation, that it's a clear, unambiguous representation. And then it might be that it's for the parties to decide instead whether the other constituent ingredients of legitimate expectation are present, and whether that can be lawfully resolved from as a legitimate expectation case law requires. I personally am not sure it's likely that the case law will go in that direction, in part because of the quite strong authority of Kebelline that was referred to here. The underpinning rationale presented in Kebelline says, I would be very hesitant to hold that legitimate expectation could be founded on answers given in Parliament to often very general questions. To do so is to invest assertions by the executive with quasi-legislative authority. This would involve an undesirable blurring of the distinct functions of the legislature and the executive. The next theme that I'd like to draw your attention to is the thorny issue of the identification of proceedings in Parliament. And I want to start with the case of ALR here. This is a Division of Court judgment which concerned provisions of the Finance Act 2025, which imposed VAT on private school fees. And there was an ECHR challenge framed through the lens of A2P1 and Article 14 read in relation with A2P1. And it was found that the measures were compatible with the right to education, and it was within Parliament's margin of discretion to decide not to create exemptions for certain groups of the VAT amount being applied. An issue arose in the course of proceedings about the admissibility of the admissibility of reports of the National Audit Office. And at first, the court took a nice opportunity to restate some fundamentals, which I think will chime quite nicely with what Gabriel was saying about the core meaning of proceedings in Parliament. So we see here the core meaning proceedings in Parliament are actions and decisions of the two houses of Parliament and the formal conduct of their members, which informs and triggers those actions and decisions. Speaking in debates, but also other formal conduct such as voting, giving notice of a motion, presenting a petition or report. Second, the court applied the Chaytor guidance on how, in tricky cases, the court might go about identifying proceedings in Parliament. This requires a two-step process. The first is asking, is a particular act sufficiently connected to the core business of Parliament? And the second is, if it is privilege required so as to protect the core or essential business of Parliament? And in conducting that exercise here, the Divisional Court came to the view, in looking at the law and practice on National Audit Office reports, that they do indeed constitute proceedings in Parliament. And to do so, the court drew on an array of different factors about how National Audit Office reports are used, looking at Parliament's historical control of supply of funds to the Crown, the practice of laying value for money reports before Parliament, their evidential underpinning of the work of the PAC, and the fact that National Audit Office reports often contain uncompromising criticisms of ministerial or departmental conduct. The next question for the court then, having established that National Audit Office reports constitute proceedings in Parliament, was whether their proposed use in this judicial review would constitute impeaching or questioning. And it's on this point that I'd like to draw your attention to what I consider to be some very interesting remarks by the court. The court said, we would question whether any of the doctrinal rationales for Article 9 justify reading the prohibition on questioning or impeaching so broadly as to prohibit any factual disagreement with the evidence given to, or indeed the conclusions reached by, a select committee. They said, looking at that lens through the separation of powers, which underpins Article 9 and privilege, we find it difficult to see why a reasoned disagreement with the factual evidence given by a witness or report author, or by the committee itself, should be regarded as interfering with the functions of the committee or failing to record due respect to it. Indeed, it may be argued that a rule requiring a court to adopt an attitude of studied ignorance towards the evidence given to or conclusions reached by a committee manifests a certain lack of respect for the important work performed in the public interest. This is very interesting because I think it's getting into the territory of understanding what impeaching or questioning means and giving due respect to the work of committees and various experts who by way of parliamentary procedure, submit reports to Parliament, may have their work engaged with by the courts. Nonetheless, it is accepted by the Divisional Court that the current authorities do not point this way. The case law since the 90s in particular, such as by way of the Preble Privy Council case and Hamilton against Al Fayed, endorse a meaning of impeaching of questioning, which means that there is a prohibition on challenging the veracity of proceedings in Parliament, which includes any challenge to the accuracy of things said as part of such proceedings. I highlight the comments there in case it may be regarded that there may be space for some development on this point. Given that the Divisional Court remarks on the present state of authorities, we consider it is too late for a change of course other than by the Supreme Court. Another factor that I'd like to draw your attention to in the line between litigation and the use of parliamentary materials is the fact that courts cannot admit parliamentary material for the purpose of establishing a contested fact. So I will start here with the case of ALR, where they reinforced that a court cannot admit parliamentary material for the purpose of establishing a contested fact, as doing so invites the other party or the court to question or impeach things said in parliamentary proceedings. What I find interesting about the ALR case, which I think might be of assistance to practitioners engaged with these issues, is that there is some practical assistance provided, or practical guidance here provided by the court in this case. The court states, we are confident that that in this particular case, there is nothing objectionable in a party extracting the key factual conclusions upon which he seeks to rely, with a view to putting those conclusions to his opponent to see if they are accepted. That is what happened here, following a suggestion made by the court at the hearing on the 8th of April 2015. And I think that demonstrates that if you are involved in litigation in this area, it may be the case that you want to seek to follow exactly this advice. So look at what conclusions you want to draw upon the Parliament, why you're drawing upon the parliamentary material. Can you put those conclusions to the case to see if it can be accepted that there is some agreed facts such that parts of that material can form part of the evidence base in the challenge? Another example here, relating back to our list of examples where materials can be used in litigation, is a recent example where material was used to determine whether legislation was compatible with the European Convention on Human Rights. This case is a recent case from last year called, I will call it ARC Time. And this provides a handy reminder of that point. The material can be used to determine legislation as compatible with the ECHR. This was a divisional court case concerning a failed challenge to amendments to the Leasehold and Freehold Reform Act 2024. And those challenges were about compatibility with A1P1. Once again, the reasons I'm drawing this case to your attention is that it has helpful guidance, once again, on litigation conduct where you feel you might want to draw upon parliamentary materials in litigation. So the court drew attention the importance of drawing the matters to the intention of the Speaker of the House of Commons. Here, the court highlighted where it became apparent the claimants wished to place passages from Hansard before the court. Permission was given to the Speaker of the House of Commons to intervene. Constructive engagement between the Speaker's legal team and the parties led to a significant narrowing of the issues as to what material the court could properly look at and for what purpose. So I think a really good example of strong engagement amongst the parties to ensure that the correct material is before the court so that they can answer the issue. This was also a case where ultimately the case was answered with very limited need to resort to the Hansard material anyway. So I think that also stresses the requirement to reflect on whether you really need it, because if it does become contested, you are going to draw out some court time and I think some correspondence time as well. A more recent case that's also identifying various handy litigation guidance when issues of using parliamentary materials arise in case law in cases is the National Council of Civil Liberties recent Court of Appeal case. This was a case which was a partially successful challenge to the finding that Public Order Act 1986 regulations 2023 were unlawful. These were the regulations where the government sought to expand the meaning of serious disruption to include anything as more than minor, and that was found to be vires the Parent Act. In this case, Underhill, Lord Justice Underhill in particular, encouraged the parties and encouraged a reminder of stressing the importance of notifying parliamentary authorities of hearings in which issues about parliamentary privilege may arise. So he said he reproduced aspects of a written statement from counsel representing the relevant parliamentary authorities, in which some concern was expressed that they had not become aware of the extensive use of parliamentary materials in these proceedings until the publication of the initial divisional court judgment. Lord Justice Underhill produced guidance that was provided in that statement, which said, first, any party may write to Speaker's counsel in the House of Commons or to counsel to the chairman of committees in the House of Lords, identifying the issue to enable the relevant parliamentary authority to take a view on whether intervention would assist the court. And secondly, the court may of its own motion inform Speaker's counsel or counsel to the chairman of committees where an issue of privilege arises, which has happened in previous cases. Another issue that I wanted to draw your attention to was an issue of the scope of protection. So when something is identified as being part of the constituting proceedings in Parliament, there then becomes a question of whether matters before something constitutes proceedings in Parliament can still be subject to litigation. And before discussing the recent Charity Commission case on this matter, I wanted to draw your attention to the case of Warsalmer and Gannon, a 2020 Court of Appeal case. And this related to the publishing by Parliament under a motion for an unopposed return procedure of a report of the non-statutory inquiry into alleged child abuse on St Helena. And whilst the report constituted a proceeding in Parliament, the Court of Appeal noted that privilege did not extend to the decision to set up the inquiry or the decisions of the panel about how to conduct the inquiry. So there was some recognition by the Speaker. The Speaker accepts that the conduct of the inquiry prior to the publication of the report is not covered by parliamentary privilege. And it's on this aspect that I think the Charity Commission case against the Parliamentary and Health Service Ombudsman is interesting, because it's giving rise to questions about the extent to which privilege extends to the prior process before a matter or material enjoys the protection of parliamentary privilege. And this was a case, the Charity Commission case involved the Charity Commission applying for judicial review of a decision letter received from the Parliamentary Ombudsman that there was a indication that the Parliamentary Ombudsman had decided and intended to lay special reports that it had released against the Charity Commission before the House of Commons. And it was ultimately the process by which the process that the Ombudsman offered to take here became different. So the claim became academic. But in the course of the divisional court judgment, there was some discussion about the potential scope of privilege here to be attached to the reports in question. And the main justiciability argument was about the special reports and the extent to which, if the question was the decision letter saying that the reports were going to be laid before Parliament was what the Charity Commission was challenging, is that the same as impugning the contents of the reports themselves? Or is that just simply establishing a challenge to the decision to submit the reports to Parliament? And Mr. Justice Fordham would have heard argument on that point, but he didn't ultimately because the claim became academic. He said he recognises that the public law issues here are famously context specific. I think the Warsalmer issue, as he refers to it as, so the issue of a prior process still being subject to justiciability, but not the actual material that ends up before Parliament, would warrant substantive ventilation. I think this gives rise to questions about the scope of being able to challenge the prior process before something is laid in Parliament. And I think ultimately in the future, you might see that turning upon the way in which the prior process is being challenged and whether that is inviting some scrutiny of the material that ultimately ends up before Parliament. I did have one final case that I was going to discuss, but actually, in the interest of time, I might stop because this was my final slide on the Greyhound board challenge against the Welsh Ministers, and it may be that these themes come out in questions. Thank you very much.
Thank you very much indeed, Elizabeth. That was brilliant. It might be good if we have time for you to say something about the Greyhound case because of how that applies in the Senedd, which is a different parliament. We're probably going to have a couple of questions, but if you did want to say something about greyhounds, we've probably got time for that.
Yeah, absolutely. Very happy to. Sorry, I was just aware that my capacity to stick to time is shocking. This is why I'm an academic and not barrister.
No, well, it's the same for barristers, frankly.
So yeah, the final case I did want to discuss was Greyhound Board against Welsh Ministers. That was a challenge to the lawfulness of the Deputy First Minister's decision to introduce a bill into Parliament in September 2025, which would prohibit greyhound racing in Wales. The substance of the challenge wasn't the validity of the act, but the prior decision of the Deputy First Minister to introduce the bill in the Senedd. And I think what's interesting about the case is that it could well have been decided simply by reading the Government of Wales Act 2006 and finding the limits on challenging bills within the Government of Wales Act itself. But to buttress that, the Divisional Court read across the relevancy of principles of parliamentary privilege here, even though parliamentary privilege doesn't strictly apply to the Senedd. So do you mind if I share again? Forgive me, just because there might be a nice quotation I can.
That's fine.
Yes, so the act of introducing the legislation forms part of the proceedings of the Senedd, and the court said that is consistent with the Divisional Court's decision in Wheeler that the introduction of a bill in UK Parliament is part of proceedings within Parliament. Ultimately, the case fails because Section 11B and Section 112 of the Government of Wales Act 2006 are where the procedure is set out by which a bill can be challenged on particular grounds by particular individuals before a particular court and at a particular time. And none of this challenge aligns with that. But what I do think is great about this case is the wider principle that it's unearthing here, relying on cases such as AXA to underpin that the authority of the Senedd here shouldn't be undermined because of the constitutional separation of powers. So although the reasoning in the relevant cases cited was based in part on principles of parliamentary privilege, which do not apply in the Senedd, it's also based in part on the constitutional separation of powers. As we have said, that is as much applicable in relation to Wales and the Senedd as it is to the courts of England and Wales and to the Westminster Parliament. I'll stop there.
Brilliant. Thank you very much indeed, Elizabeth. An important point in a sense, I think, to end on, recognising the importance of parliamentary privilege in separation of powers. So if anyone has any final questions, please do use the Q&A function on the system to ask them. There's a question I'm going to put to both Elizabeth and Gabriel, which is asking, I suppose, about where we are and whether it matters in constitutional terms. Because, I mean, if we accept that there is rightly a prohibition on challenging parliamentary actions or decisions like a decision to introduce a bill and things associated with that, like compliance with the public sector equality duty or consultation. And as far as parliamentary materials are concerned, you can deal with that, for example, by agreeing facts or using sources outside Parliament which are not covered by privilege. And obviously that's hard work in case management terms, but maybe not impossible in many cases. So where do you think that leaves us? Is there any real problem with parliamentary privilege as it stands, a gap in access to justice, or a kind of an unfairness issue where because relying on something might invite the questioning of it, you can't rely on something unless it's accepted by the other side? Or do you think we're kind of in a happy or at least a tolerable place as far as parliamentary privilege is concerned for the conduct of public law litigation? Who wants to go first on that? Gabriel.
I was going to invite Lizzie to go first, in truth, but I can quickly comment, uh, which is that I would probably fall in the happy medium camp. Um, I think a lot of it comes down to what we're dealing with, which is essentially a piece of 17th century legislation with associated common law principles around it. And so the courts are constantly having to deal with novel issues and issues that perhaps haven't arisen before in terms of how they've considered it thus far, subject to further consideration, for example, like that proposed by Justice Chamberlain. I do think we found a happy medium in that the proceedings in Parliament have been protected for the important reasons stated by Lord Burnett in the quotation I cited, but the ability for parties to conduct litigation and effectively hold governmental and other public bodies to account has been protected. So that would be my view.
Yeah. Elizabeth.
I wonder, I don't know whether I have an answer, in truth. It's quite a thorny question. But one thing that I think, I wonder whether the divisional court judgment I drew attention to, ALR, where I thought there was some pushing at the question of whether the meaning of impeaching and questioning shouldn't extend to still being able to essentially test the evidence base a little. I think that might be, I can actually see the argument both ways, really, which is sometimes you may be in a situation in judicial review where not being able to test that evidence base absent, those materials really is going to maybe give rise to unfairness. On the other hand, I can see that if we're thinking about how Article 9 has been broadly framed over the last, well, particularly since the 90s and the incorporation of the kind of relevant Section 16 of the Australian Privileges Act and the way in which impeaching and questioning has been sort of imbued into our case law that way, I think it is quite hard to see a world in which, on current authority, impeaching and questioning doesn't just mean you can't really say much more other than accepting facts in various reports or materials. So I can see a world in which that might give rise to some unfairness. Equally, I have a feeling, and I think I've been on the record before in conversation with you, Richard, that there might be a countervailing drift here towards ever greater use of this material, which I think might be one of the reasons that some of the case law I drew attention to was sort of rowing back a little bit on reminding parties of the process they should follow should they think they need to do that, because the evidence base in judicial review is growing.
Yeah, and we may be seeing similar things with the use of pepper and heart, Hansard material, of course, being more demanding about that. Well, maybe one final point to put to you both. Again, what about the other side of the coin? So if these issues are not for the court to adjudicate on, do you have confidence that Parliament is able to deal with those things? If we're talking about things like, was consultation running up to a bill lawful? The legitimate expectation arguments, Elizabeth, you were mentioning earlier. Is Parliament really capable of dealing with those kind of arguments when it's scrutinising a bill, say, or is it able to hold ministers to account as a substitute for the courts?
I suppose our experience in the last 30 or so years of systemic administrative failures might suggest no. But I hate to be so negative. I think particularly the work of the Parliamentary Ombudsman, the National Audit Office, these are all materials that can also be used by strategic parliamentarians, campaigners, and they have a vitally important role. So I'm not to say that it doesn't make a difference, because I think it can do, and I think the parliamentary ombudsman, it's not entirely my expertise, but sort of own initiative powers that we're seeing that are growing in the ombuds sector are particularly interesting as well in that regard. And it's a really important facet of our political constitution, so we should guard it jealously.
Thank you. So that may be a good note to end on. So we should move from just thinking about civil servants having a judge over their shoulder to an ombudsman and a select committee over their shoulder, perhaps, as well. But thank you both very much indeed for that. A really fascinating subject, but one with real political potential practical pitfalls for those people bringing or defending public law litigation. You've both dealt with it brilliantly. Thank you. So it's 2 o'clock. I'm going to draw the webinar to a close. We've got another public law webinar coming up soon on the 11th of June, where Kate Ollie and I are going to be talking more about avoiding pitfalls in judicial review, covering both substantive and procedural issues. So I hope you'll be able to join us for that seminar. Just finally, thank you again, Elizabeth and Gabriel. That was excellent.
Thank you all.